I have Margaret Love. My screen just popped back up now. Margaret Love, Executive Director of the Collateral Consequences Resource Center.
Good morning. I'm very happy to be here. CCRC tracks and analyzes legislative trends in all U.S. jurisdictions relating to relief from the legal restrictions and discrimination based on criminal record. So I'm here, in a sense, to provide some national context for the bills you have pending before you. In the past 2 years, more than 2/3 of the states have enacted reforms expanding access to expungement, record sealing, and other forms of record relief. Given the progressive steps taken by the district in the past year to improve opportunities for people with a criminal record in voting and occupational licensing, we are optimistic that the council will enact significant improvements to its record sealing law. And to be candid with you, DC has a long way to go compared to states across the country, including, perhaps surprisingly, states like Indiana, North Dakota, New Hampshire, and Utah. To begin with, DC's non-conviction sealing scheme is one of the most restrictive in the country and out of step with national trends toward automatic and expedited sealing of non-conviction records at or shortly after disposition, without regard to the person's other record. DC's law on non-conviction records is more complex and harsher in 3 primary areas. First, the waiting period before a person may apply for sealing a non-conviction record is longer than almost any other state, and the effect that a prior or subsequent conviction has on extending this waiting period is unusually severe. Second, the provision ruling out sealing for a successfully completed deferred sentencing agreement based on the person's prior or subsequent record is counterproductive and harsher than the norm, and inconsistent with trends in the states encouraging these diversionary dispositions. Third, the procedures and standards that apply in proceedings to seal a non-conviction record are more burdensome and restrictive than in any state, differing little from the procedures and standards that applied in sealing a conviction record. As to conviction records, DC sealing law is narrower in scope and more demanding in process than most states. Its 8-year post-sentence waiting period is far longer than the 3 to 5 year wait in most states for misdemeanor sealing. Only one state, Iowa, imposes as long a waiting period as DC does. Moreover, a person with an otherwise eligible conviction may be disqualified by virtue of their other record. In contrast, 41 states now authorize misdemeanor sealing without regard to an individual's other record, and 34 states also authorize sealing for a range of felony convictions. Given the progressive steps taken by this council just in the past year, we're optimistic that DC can make substantial improvements in its sealing law, both in broadening the scope of eligibility and relaxing procedural barriers. There is no reason why relief for non-conviction records should not be automatic at or soon after disposition, as it is now in states as varied as Nebraska, Pennsylvania, Utah, and Vermont. A bill awaiting the governor's signature in Virginia will add that state to the list. DC would also benefit from drawing a clearer distinction between non-conviction and conviction relief. Even if DC decides not to go right away to full automation in conviction sealing, it would benefit from studying the petition-based schemes in states like Iowa, North Dakota, Illinois, and New Mexico. The bill that we expect will soon be signed in Virginia also has commendable features. So with that, I think I will stop and refer you to my written testimony, which has some more details about DC's law. Thank you very much, Mr. Chairman.
Absolutely. Thank you.